Hi everyone, welcome back. I am Catherine Medina, also known as Attorney Catie Online. I am a divorce attorney located in Phoenix, Arizona, and owner of Medina Family Law. If you are watching this video, it is because you want to learn a little bit more about the family law system in Arizona without things being too complicated, which is primarily what my content is about. Obviously, YouTube is for longer form. If you want to check out some of my shorter form content, please go to my Instagram as well as my TikTok. Okay, so today I want to talk about what is called a resolution management conference. We also call this an RMC for short. Now, a resolution management conference is typically the first hearing that you're going to have set in your divorce case after you file your petition for dissolution, which we went over in a prior video. I will put the link in the description box if you have not yet seen that. So after you file the petition or the request for the divorce and your spouse files the response or their answer to the petition, the court will set a resolution management conference or an RMC. Now, post-COVID, these are happening primarily virtually, at least in Maricopa County. There may be some smaller counties that are doing these in person, but for the most part, they are taking place as we sit here in June of 2026 virtually. Rule 76 of the Arizona Rules of Family Law Procedure says that the purpose of an RMC is to facilitate agreements between the parties. So it's really simple. The purpose of this hearing is not to hear evidence, to hear testimony, to put on a whole big trial, for the court to enter rulings. The purpose is just to help the parties try and reach agreements if possible. And so the practical side of this is that many parties that go to an RMC, which as I said is the first hearing for a lot of people in the divorce or custody case, many parties that go to the RMC are in the early stages of their case such that there are no agreements that have been reached at that time. Or if they are, they're minimal. And so if you have agreements that you have spoken about with opposing party or their attorney and you are really clear about the terms of those agreements, you can agree to put them on the record at the RMC. I will talk about that next. But I also want watchers to know that if you do not have agreements and you don't have anything to put on the record at the RMC, that's okay too. If you have agreements because you've spoken with opposing party or their attorney, and you are really clear about what you guys have agreed to, you can put those on the record at the RMC. However, you don't have to put any agreements on the record at the RMC if you don't have any. And it is completely normal not to have any agreements because by this stage of the case, you're in the early days of your case and may not know really what agreements you are going to reach or have any idea what you would even be comfortable agreeing to. And that's completely normal. When we say that you can put the agreement on the record at the hearing, it typically means that you would record orally at the court hearing what your agreement is. And the court will ask you a series of questions affirming that you agree, that you understand the terms of that agreement and are entering into a binding agreement and that no one has forced you into those agreements. That would make your agreement, whatever it may be, that you enter at the RMC, a final binding order. Sometimes people are doing this, like I said, it depends on the case. But if you have agreements early on in your case, great, and you're like, we want to solidify these, we want to make sure that we get this agreement finalized so that no one changes their mind, the RMC is a great opportunity to do that. But we're not seeing this in a lot of cases unless the parties have already spoken about issues prior to filing and were able to resolve things on their own. Because by the RMC, you're supposed to have completed your initial disclosures. And so you may have just gotten a ton of information and a ton of documents about all of the assets in your case, but not yet had an opportunity to look at them and decide what you're comfortable agreeing to, which again is normal. So For a lot of people, they go to the RMC and don't yet know what they're going to agree to. For a lot of RMCs, people are showing up. The attorneys, if there are attorneys on the case, are communicating to the judge, hey judge, this is what's happened so far. I've spoken with opposing counsel. This is how we want to handle the case for the next 30, 60, 90 days. So you or your attorney, if you have an attorney, are going to be required to do what's called a meet and confer. This typically has to take place at least 5 days before your RMC because you are meant to meet with the other party and talk about possible agreements. So if you are represented by an attorney, the attorney will reach out to the opposing party or opposing counsel if there's another attorney on the other side, and they'll talk about any potential agreements to find out if there are any. And then when you go to the hearing, you'll have told the judge, we've spoken, we've reached agreements, this is what those agreements are. Or we've spoken, we don't have any agreements at this time, but this is our plan for the case. So in addition to being a hearing to facilitate agreements, this is also a hearing to help move your case along in the system. Because if you don't have agreements at this stage, okay, but let's tell the court, what is it that we're doing to try and reach a place where we might have agreements? Or if we're completely unable to reach agreements, what is our plan after that? Are we preparing for trial? Are we resolving discovery or disclosure disputes because we're not getting all of the documents that we want, or we think that there's something else? So this is really a check-in, your initial check-in with the court to say this is the status of the case, this is our intended goals right now, and we'll come back if we need anything. And that's a lot of the time what the judge will tell you at the RMC is that I'll leave you guys to it, I'll let you guys be, you let me know if you need me. But you're in the initial stages of your case, unless you're filing a temporary orders request. You guys are really trying to work it out amongst yourselves right now. The court isn't involved immediately unless, again, you're filing a motion for temporary orders, which will be a different video from this one, which you may end up needing to do in your case. However, this is something that you should absolutely talk to your attorney about because there are several factors and things to consider before filing a motion. So your RMC is typically going to be shorter, anywhere from 5 to 15 to 20 minutes, depending on whether or not you're putting agreements on the record or speaking with the judge. Because they are shorter, that is why a lot of them are taking place virtually still, as opposed to having to go down to court for such a short hearing. Now, there's a really important piece of the RMC that I have not shared with you yet, and that is that you are going to be required to file what is called an RMC statement. Both parties are required to file this, and this filing does have a deadline attached with it, so you'll want to pay extra attention to the minute entry that set this hearing, because the deadline to submit your RMC statement is going to be included in the minute entry that you received when the RMC was set. Now, the RMC statement is to set forth any potential agreements that you have with the other side, as well as a proposal to resolve all other disputes or division of assets or custody matters in your case. And it must be, this is important, free from argument. Free from argument means that your RMC statement is not going to have the why you are asking for certain things. So you're not going to be making an argument in your RMC statement to support your request for your division of assets, for your custody request. It is literally just telling the court what you want. The purpose of the RMC statement is to let the judge know prior to meeting you for the first time whether or not the parties might have any agreements, or whether or not they might be close to agreements, or if they're really far off at this point in the case. The judge can typically discern that after reading both of your RMC statements and seeing, well, what are they each asking for? Are they really close? Are they far off? Is this going to take a while? But it's important to know that if you want to reach any agreements at the RMC, these have to be what we call stipulated agreements between the parties. This is not something that the court can force on the parties. The court cannot decide any of these contested issues for you at the RMC. So the only agreements that you could potentially put on the record at the RMC are agreements that you have both agreed to, that you are both okay entering. If you need assistance, there are a number of things that you could ask assistance from the court at the RMC. I'm going to include here a list of all of the things that the court may do at this RMC. If you are in a really complicated case, let's say you need emergency or time-sensitive orders for financial matters, for payment of bills, for temporary custody of children, then you may need to consider filing a motion for temporary orders. And if you do that before your RMC, you may even be able to set a hearing at the RMC, an evidentiary hearing, that is, at the RMC to keep your case rolling. The last thing I want to talk about at the RMC is something sort of procedural that happens that can confuse some people, and that is setting your matter on the inactive calendar, or what's also known as the dismissal calendar. So when you have your divorce case going through the court system, it has to remain an active case. While you and the opposing party are trying to work things out, or the attorneys are trying to work things out, or while you're going through discovery and disclosure, your case needs to remain active. In other words, it cannot get dismissed off of the court's calendar. Otherwise, there's no active divorce case in order for you to eventually finalize your divorce. So when you are at the RMC, you are going to hear that they are setting this matter on the inactive calendar typically for X amount of days. That can range anywhere from 60 to 120 days, depending on the stage of your case and how quickly it is moving. It does not mean that your case is dismissed. It does not mean that on that date of the inactive calendar that you have another hearing. It just means that by that date, by the inactive calendar date, the parties must tell the court either we have reached an agreement and here's what that agreement is, or two, we don't have any agreements but we're still working on it and we need more time, and set it for another inactive calendar date for another 30, 60, 90 days, whatever it is that you may need. Or we've tried, we don't have any agreements, and we need a hearing. Either one of those scenarios needs to occur by the inactive calendar date, because if the inactive calendar date comes and no one has told the court what's going on, are we continuing, do we need a trial, the court may well dismiss your case, and then you have to go through a process to reinstate your case. So it's very important that you keep your case active if you are still pursuing your divorce. That's all I have to share today about a RMC, also known as a Resolution Management Conference. As always, follow this channel or follow my social media if you want more bite-sized information about family law here in Arizona. I am Catherine Medina, owner of Medina Family Law. I hope to see you again.